Thank you very much.
Yes.
Excellent presentation. I have a question about will.
Yeah.
I have heard many suggest that I registered the will that I made in Thailand. Others that I should have witnesses on the document.
Right.
Others say the opposite. Is there any regulation how you register a will, or is it not necessary? Just tell my wife where it is?
Yeah, it's not necessary, but a lot of Thais will do it. It was funny because I was talking to one of my probate lawyers before coming here, and just a general conversation saying, why is it that it's only expats that come to see me about making wills, or their Thai partners? I don't get Thai clients coming in and saying, I want to make a will. And the answer he gave me, which made me chuckle, was only rich Thai people make wills. Poor people don't. But even then, those that do can do so relatively cheaply on a DIY basis. And this is what I think you're talking about, because what most people will then do is go to I'm not going to try and pronounce it, but it's a government department where officials, the two witnesses to the will be officials, and they will sign it at a grand cost of about 60 baht. So a lot of Thai nationals will either not make a will, or if they do, they'll do it on the cheap, they'll do it on a DIY basis, and they will register it. As an expat making a will, do you need to register it? The answer is no, but you can do if you wish. You can have a will drawn up and you can go through exactly the same procedure as a Thai person would. It has to be in Thai. They're not going to witness it in English. It has to be in Thai. Do you need to register it? No, you don't. It's just one extra step along the way to probate, but it's not really a bar. I think what, coming to another point which is commonly raised, is I've got a will in the UK or I've got a will in the States, surely that's valid? And the answer is yes, Thailand recognises foreign wills, but it's a very cumbersome, expensive exercise to get to probate because you have to involve the court. Whereas with a properly drafted Thai will, you can administer a estate without actually going to judgment, going to court. So the answer is yes, you can do it, but it's a voluntary exercise. It's not something that's compulsory.
Yeah, I missed the first 5 minutes, sorry.
Sure, that's all right.
The wills. I just want to know, can you do two wills? One, say, in overseas,
Yeah.
and for the overseas assets,
Mm-hmm.
and one in Thailand, the Thailand assets?
Yes, you can, and many people do, and they restrict it to assets. I'm not an expert on tax, but this is where it does get very, very complicated, because you might do that and say, I restrict my American will, for example, to my American assets, but the American government may not recognise that. I know a little bit more about the UK, where there is now a codified system. There's an Act of Parliament which says if you're domiciled in the UK, and there's definition of domicile, and there's tests you have to pass, you realise whether or not you are taxable in the UK or not. It also depends on whether there's a double taxation treaty with Thailand, and there's not many of the Western countries that have a double taxation treaty. So tax is a major issue when answering that question properly. But yes, a lot of people do it.
The reason I'm getting to it, because you sort of say that it's, when you register, it's a last will and testament. So you have to say the last will and testament.
Well, this is a very good point. Do you actually simultaneously sign the two wills? Because that's a very, very good point. And it's somebody asked me the question, and quite frankly, I mean, I've got Stephen here as a lawyer, maybe able to help us, but I don't know the answer to that question. Logic dictates that if you sign a will here and then you fly over to Australia and you sign a will there, and there's 2 days apart, the last will prevails.
I actually went to my lawyer in Australia before I came back here last time.
Right.
And I have quite a complicated will in Australia. He said if I make a will in Thailand, it will override my Australian will.
Well, that's what I would have said. I mean,
So that is, my Australian will automatically becomes null and void.
I would have thought that you could say last will and testament for my Australian assets.
All you can
and
do
then for my
is
Thai assets.
Well, this
you
is
have
what
assets here,
Yeah.
And that's another thing, company investment and
Specify for Australian
apartment.
assets.
You have to have the certificates of those company investments and the purchase of your apartment in Australia, with your will in
I think
Australia.
that's what Gav just said.
Yes, yes.
Basically, in many cases, it's not the law, but the sensible and practical thing to do is to make a will for each country where you have significant assets.
But my,
It simplifies.
Yeah, but it
Okay, but my
specifies
lawyer
for
was
Fine,
trying
you
to
just
set it
add
up
into
right.
the Australian will a will to words to say this will only applies to my assets in Australia.
Yeah.
Yeah. And then to be totally safe, make sure the date's the same date. You know, and then who's going to check whether which one was signed which
So it
first?
should not matter if you put Australian assets, specify that only. And specify
Yeah, and a lot of people do that. The general consensus is that if you make a will, it should be for your worldwide assets. But of course, you do have this strange situation amongst expats who, you know, moving around between different countries and have assets in different countries. And yeah, you know, it's a common practice for it to be
Don't
done.
worry about the tax aspects because Thailand does have a double tax treaty with many or 50-odd countries.
Yeah,
So it's
yeah.
not a problem there. And
Yeah.
the double tax treaty only applies to income tax, not inheritance anyway.
Right, okay. Well, yeah, I stand corrected on that. But yeah, as I say, it's common practice. A lot of people do it, and to be honest with you, I haven't come across a situation where it's been challenged. So it's not something I can really speak to experience on. Okay. Yeah.
If you have a will here and you write it in English,
Yeah.
is it valid?
It's valid, but it's far better to have it translated into Thai and signed in Thai, because if not, then you have an extra step of going to the Foreign Commonwealth Office and going through rigmarole and getting it translated officially at anywhere between $28 to $35 per page. So it just adds to the expense. But yes, it's perfectly valid. The fact that it's not in Thai doesn't invalidate it.
The executor in Thailand is, well, it's preferred probably. Does it have to be Thai or it can be anyone?
No, it can be anyone. No, it doesn't have to be. It's just a person of capacity, so an adult, a person or an entity, juristic person. Yeah. Sorry, yeah, back.
Are you saying on the double taxation that the UK tax authorities are not going to find out about my selling my apartment in Thailand?
It depends.
And going to it's going to add to my tax liability for inheritance tax in the UK.
It could do. If you're deemed domiciled in the UK, and that in itself is a lecture in itself. I mean, in simple terms, if you have no assets in the UK and you have nothing to do with the UK, there's not a great deal to worry about. But if you've got a home in the UK and you go back there for a month, a year, then you might have something to worry about. So it may well be, even though you're trying to protect your assets from the UK taxman, you're not going to succeed unless you pass the domicile test. So, and of course,
find out?
the
property in Thailand.
yeah. At the end of the day, if it's a Thailand will, Thailand executors, Thailand beneficiaries, then you know.
Let me share that a little bit on
Yeah.
the tax diamonds.
Okay.
Wills and property, right?
Yeah.
Share a little bit with you about that. The governments of each country do or can share information under double tax.
Yeah.
There's an article there which says they should and they can.
Yeah.
As a practical measure, they don't. I mean, Thais don't understand English, they don't care. They're not going to know what assets you have in the UK, and UK won't know what assets you have in Thailand, because it's not going to be shared as a practical measure.
Thank you. That's good.
Yeah.
I think also if you're domiciled in the UK, which as you said is difficult to determine whether you are, but most of us actually are, even though we've been overseas for a long time,
Yeah.
for inheritance purposes, whilst if you're British, then the British spouse would actually receive your assets without inheritance tax.
Yes.
If your spouse is Thai and not a British citizen, then that spouse will have to pay inheritance
Yes,
tax.
of
Certainly
course.
in
Yeah.
the UK assets.
Over 325.
But I wonder how it actually rebounds off into your Thailand will as well.
Yeah. I mean, generally speaking, I think what most people, you know, unless you're very, very wealthy, and again, you know, a will is not the end of a problem. If you've got taxation issues, you really need to be looking at financial planning generally, because there's lots and lots of ways of divesting yourself of assets during your lifetime, of tying things up in trust outside the UK, offshore, and so on, getting around tax issues. But you know, most people don't worry about that unless they're quite wealthy.
Thank you.
Yeah.
I'm not wealthy, I've got my way.
Wealthy time.
Yeah, thank you for your time. Just a quick question going back to the UCFRAC contract.
Yeah.
With regards to an existing house being built on land.
Yeah.
If the tied spouse passes away first, what's the situation then?
It's still binding. It's still binding on her heirs.
Okay.
But it dies with you.
Okay. So with regards to selling the property, who does that protect the?
Well, in a normal scenario, you would, if you're selling the house, you would agree to remove the usufruct. It's a contract.
Okay.
So you can.
Sorry, I mean, if the tied spouse was to pass away,
yeah,
and I was to be left in the property alone,
yeah,
and I then wanted to sell the property.
Well, assuming you weren't the beneficiary of your wife, assuming somebody else was, then you'd have to negotiate.
Okay.
I mean, one would hope that you'd be a beneficiary, a primary beneficiary, so you're one and the same person. But yeah, if she leaves it to a cousin up north or whatever, then you're going to have to negotiate. You've got a right of occupation, so you can't sell it from under you. Therefore, you would negotiate and say, well, okay, she left you her share, which happens to be 50% because it was a joint matrimonial asset. So if you give me 50%, I'll give up my right of use for it and I'll move out. That's how you negotiate. Yeah. Yes, sorry.
Can that contract, does that contract have to happen when the house is bought? Or can it be done any time?
It can be done at any time. It can be done because it's a right of occupation.
Yeah,
It can be done at any time, but it's a good idea to do it while you're at the land registry, registering the land.
yeah.
And in any event, if you're married, as I mentioned, that you have to sign this declaration, you have to go in as a spouse to sign this declaration. That's the time. Declaration signed, here's a usufruct contract. And I think it's about 80 baht to register it, so it's relatively straightforward. And again, they have their own version of it, you know, so you don't necessarily need lawyers to deal with it. But obviously, if you can't read Thai, then you know you probably want a precedent to take in Thai and in English. Yeah.
If you're married and you want to leave your Thai assets to your Thai wife, and your British assets to your daughter,
right?
Can the wife contest against that?
In a death situation or in a death situation?
Will be dead.
Yeah. No, but again, in terms of the interaction with matrimonial law, it's when it gets complicated. But yeah, on death, yes, there's nothing wrong with that. There's nothing wrong with that.
So they can't really contest it.
Yeah.
Okay, the second question is...
It would be exceptionally difficult for them to do so.
Can I perhaps add something to that? In the UK, including Scotland, we have something called an Inheritance Family Provision Act,
Yes.
which means certain categories of person, a spouse, a former spouse not remarried, a child, a person treated as a child, or a person maintained by the deceased, can apply to the UK courts for provision if they're being totally or partially disinherited under the will or under the intestacy rules. You don't have anything like that in Thai law.
No.
So a Thai party can't seek to challenge the will or the intestacy in that way. But there is theoretically an exposure to that. So you want to say everything in Thailand to my Thai spouse. She could theoretically bring a claim in the UK courts of family provision on the grounds that you've partially or totally disinherited her.
Right, okay.
Yeah. And don't forget the spouse entitlement is another complicating factor. So if she were being advised, well, hang on a minute, the property in the UK, is it jointly owned property or is it personal property? Was it bought during the course of the marriage or not? So it may give rise to a claim
That
in that
was
way.
second.
Yeah.
Just jump into the second question.
Yeah.
Is that if I'm married here and I bought an apartment or a house here with my partner, and then we get married afterwards, and I want to use this Uber fund, whatever it is, that's not a problem. But
Yes.
I cannot use, there's no other protection I've got, because even though we both bought it,
Well, don't forget, if you bought it before you married, it's your personal property, it's not joint property. So if you
it's in that
reinvest,
person's name.
if you then reinvest that after you married, it becomes joint property. So you bought the apartment before you were married, correct? Okay. Up to this point, it's your personal property. It's not joint property.
Well, actually, we both bought it.
Oh, you both bought
Just
it. Okay.
4 months ago.
Okay.
And we're getting married next 4 months.
Okay. But as soon as you
The wrong way round.
basically, if you acquire an asset after your marriage, it's jointly owned. And Thailand is very good in that sense because it's very clear in its definition.
Well, we've already got it, so
So it's jointly owned property.
not yet. Well, it can't be. I'm not married yet, but because we've already purchased it.
If you purchased it together,
Yes, but the mortgage will, because we can't get a mortgage because we're foreigners,
Right.
is in her name.
right?
The land title's in her name.
Right. Now, hang on. You
See where I'm going?
I can't see.
Taking flowers home tonight.
I can see where you're going, and this is actually something I'm dealing with right now. So it's a very valid point that you raise. Mortgage companies, if you borrow from a Thai bank, will never ever allow you to register anything against the property until you paid off the mortgage. That's policy throughout Thailand. That's the National Bank of Thailand talking, not a particular bank. So unless you have a foreign bank, potentially UOB, who are mortgagees, they are not going to allow you to register a usufruct, let alone a superficies. So you can't. They will not have any encumbrance on the land while they're owed money.
But the Uber fund is not a contract on the land.
Yeah,
It's a contract on the building. Yeah?
I've actually argued this, and I've got a ruling from the National Bank of Thailand. They won't allow it. It's an encumbrance on the property as far as they're concerned, because it gives you a right of occupation. The mortgage can't be in your name; it's in the Thai national's name. So therefore, a non-borrower is trying to register a right, won't allow it.
So basically, there's no protection whatsoever.
There's no protection if you've got a mortgage, other than a contractual relationship with your spouse.
Like being a lease.
Yeah, a lease or an agreement. The agreement that you're a 50% owner. It's not binding against the mortgage company, but it is binding against everyone else. It's a contractual relationship that you've entered into. So you can enter into a contract with your spouse. You can even enter into a loan agreement. I've seen spouses enter into loan agreements
Get a prenuptial.
where I've seen situations where an expat spouse has brought in money from overseas and actually got the spouse to enter into a loan agreement with him, but it's not registrable because there's also a mortgage. What I have also seen where it's a mortgage-free property is a mortgage where the foreign spouse is the lender and the Thai national is the borrower. So you can actually enter into that relationship as well. You can be a mortgagee for your spouse, but that's if you don't have a commercial mortgage. If you have a commercial mortgage, you've got none of those options. All you can do is enter into a contractual relationship, and then if a dispute arises, it's off to court to say, well, you know, here's a loan agreement. I paid for half the property. So that's the only protection you've got. So unfortunately, unless it's a foreign bank, you can't register a protective right against the property because they just won't allow it.
So I need a lawyer to write the contract.
Yeah, I actually challenged it because I thought it was a particular bank which I won't name, and this was down in the south, and I thought they were just being awkward. But then we rang a couple of other banks who had the same policy, and then we went through to the National Bank, and the National Bank said, no, this is the policy. No Thai bank will allow anybody to register anything while they're owed money.
Okay.
I've got a question. If I had a son, he's a Thai national, can I register my land under his name before he turns 18?
Over the age of 12, yes. 12 and over.
Okay.
bizarrely, a 12-year-old child can own land.
And after that, the change of ownership,
Yeah.
do I sign for him or he has to sign?
Well, this is the bizarre thing. You would sign as his guardian because he's 12. He's under the age of majority, which is 20 in Thailand. But he can own land, yes, as soon as he's 12 years old.
Then it's both me and the mother, both signatures, or just me?
Either or. Yeah, it's a guardian. Yeah. Or both of you would be preferable, but it can be either parent.
Is there a problem with owning land, putting it, say, in your Thai wife or your son who's 12,
Yeah.
and proving that the money came from them?
No, no. I mean, this is why the land departments quite often recognise that money has come from not the owner of the person who owns the land, but that's why they make you sign a declaration to say you're not going to have a claim on that money just because you paid $5,000 to buy the land. Don't come crying to me afterwards and saying it's your money, because it isn't, because you gifted it to your wife who's bought the land, or to your son who's bought the land. And the same would happen to this gentleman's son. A declaration would be signed to say it's the son's money, not mine. I've gifted it to him, which is perfectly legitimate.
But does the land department do that every time? Because I bought a property, I mean, I've got rid of it now, thankfully,
Yeah.
in Phuket, and they never asked for that evidence at all.
They will only ask for it in the case of a spouse. They won't ask for it in the case of a partner, and they will ask for it in the case of a minor.
But I put it in joint name with the spouse, and didn't ask them.
You put it in joint names.
Yeah, it was a lease, a leasehold, 30 years.
Lease is separate, yeah. Lease you can. Lease is a contractual thing, yes. Yeah.
Just putting both names.
Yeah, lease is fine. You could have a lease with multiple parties. You could have 4 or 5 friends who have a lease. Yeah.
But it's still, you know, I mean, yeah.
Yeah. So I mean, you could potentially have 4 or 5 foreigners who lease a piece of land. That's not an issue. That's not an issue. I should just mention, because the gift thing comes up, that Thailand is very, very generous on allowances, much more so than foreign jurisdictions, of divesting yourself of property during your lifetime. I'm just trying to find the relevant provision. But certainly if you want to get rid of some of your assets during your lifetime, okay, so we said 100 million for threshold for inheritance tax. You can give away up to 20 million baht to a son or daughter, a direct descendant. You can make gifts of 20 million baht in any calendar year, and you can even give away, for the purposes of marital and ceremonial issues, another 10 million on top of that. So it's quite a generous allowance.
The biggest joke of legislation ever introduced.
Yeah. I mean, who would do that? I don't know, but I suppose if you're wealthy enough and you want to divest yourself of some assets, that's a good way to do it.
Well, the politicians are about 98 million, you know.
Yeah, sorry.
Just not to give my full personal history away, but I was married once before, and when I got divorced, the lawyer basically said that any marital assets, including the land, and I spoke to TMB Bank executives, everything went 50% right down the line. Yeah, in matrimonial lawyers, that's quite right. It's separate. It's a separate issue. It's a jointly owned asset, unless you sign a declaration to the effect that it's not a jointly owned asset. But if you try and register land now, since the laws have tightened up in 2016 onwards, you would, as a spouse, sign a declaration to say, not my property. So presumably you did this pre-2016, did you? Oh yes.
Yeah. Some time ago.
In that case, could you get them to sign something to say that this is now declared as part of the marital assets prior? Yeah?
No, because the whole purpose of this tightening up on regulations is because they don't want foreigners to find ways of getting proprietorship in land. So they're doing everything they can to prevent that from happening. So your nominee is gone, your company to buy property is gone, using your spouse has gone, Because if you say to a spouse, okay, I want you to sign a declaration, you're taking proprietorship rights to the land. Therefore, it's not going to be allowed.
So could you take proprietorship rights to the building in
The
context?
building you can if you're building in the course of construction.
Knock it down?
And if you have a mortgage, then no, you can't, because the mortgage company won't let you unless it's a foreign bank.
Right.
If it's a foreign bank, and again, this is common in Western jurisdictions, you can register stuff through something called a deed of postponement. So what you say to your mortgagee, to your bank, is, I have a right over this land. I acknowledge that your right comes above mine. Therefore, in the event of default, I can't exercise this right against you, but you can still register it. Okay, not so in Thailand, because you need the consent of the mortgagee to do that, which the Bank of Scotland or NatWest Bank or Barclays Bank would give you, but not a Thai bank.
Okay.
Since I got married, my wife's mother has given her a piece of land.
Yes.
Does that then become joint property?
If it's given to her during the course of your lifetime, there's an argument to say that it is, but then she's got another provision where she can say, well, no, it was a gift.
It's supposed to be the other way around.
Yeah. You can certainly argue it because it's acquired during the course of your marriage, but then she will try and use the gift exemption, saying, look, no, actually, it was a gift purely for me. But again, she needs fairly strong evidence. She would need something in writing from the grandma saying, this is a gift for you, and is to be excluded from the matrimonial assets.
Thank you.
Yeah.
Where does common law marriage sit in all of this here? Because we're married in the UK, but we're not married.
Yeah, it doesn't. I mean, the matrimonial laws would not apply unless your marriage is registered here in Thailand. But of course, you can register a British marriage here. Yeah, you can go through the registration process. You don't have to have another ceremony. You can actually register it. So if you want to avail yourselves of, and I have to say that the matrimonial laws here, I think, personally, I think are excellent. They're much more clear. In the UK, we rely very much on common law and on rather than legislation. There's a lot of legislation there, but there's a lot of grey areas. Whereas in Thailand, it's pretty straightforward. I mean, it's a case of tracing the money. Where did it come from? Where did it go? When did you acquire it? And you can start to separate out assets when there's a breakdown. So it's fairly clear.
And the other question is, if you buy a condominium, right, and you brought the money in from abroad, am I right in saying that if you sell that condominium, you're only allowed to send out the same amount of money that you brought in, or not?
I haven't heard that, to be honest. Stephen, have you heard anything like that?
No.
I don't think so. I mean, I can tell you this thing, you can't send out the foreign currency, other than you'd have to change it here. You have to sell in bar and then change it back through a bank here. You can't send it out in bar. I'm not.
I've read that actually, because I bought a property in Phuket. I went through UOB, but no bank loan.
Yeah.
But they asked me to specifically keep the funds that come from Australia, so that you can prove you want to send back that amount.
So
I work here.
I don't know the answer
Finance
to
from Australia totally. So
I don't see why.
I don't see why either.
I don't see why you wouldn't be allowed to send back what you brought in. But whether you could send back
what you brought in. He's asking whether he can send more.
More back.
Yeah, say if I bought for 5 and I sold it for 10.
Yeah. You mean the profit element?
The profit on it.
Yeah,
I've been told you can't send the profit out of the country.
I was able to do it because I had a work permit, and they can't tell whether it's my salary or my sale of the property, because I actually sold the property.
No, if you sell the amount that you sell of the property, and you have the sale and purchase agreement, when you went to add the land registry, you have all the document including the title deed, that you've been transaction complete, and then you show to the bank, this is the money that came from, because you sell the property in Thailand. You have the choice to transfer all the money that you sell.
That sounds logical.
It does. I just wanted to clarify.
That sounds like, I don't know 100%, but that sounds right.
That's actually logical, but they were saying the same thing. They were saying that you should keep records, but you can only send back what you bought in, which is stupid. It's more logical if you sell it, if you prove that you sold this amount.
If you prove it's come from that asset, I can't see why
So can I
not.
share some? So this is in case that you bought it, after you sell it after you registration the property at the land department.
Yes.
But in terms of if you buy the property for like investment and would like to sell it before the completion date, like the off-hand budget.
Okay.
So in that case, you cannot, at the moment, the Bank of Thailand not allow to the foreigner to transfer the profit.
Right, okay,
To-
okay, so to stop, this is to stop property speculation.
Yes.
Right, that I can understand, yeah, okay, fine. All right, thank you, that's, yeah. I've had the property a long time.
Right, yeah. Is it an investment property?
No, it's,
Right.
we bought it, you know, we haven't rented it out.
Because it makes sense that they wouldn't allow you to do that with investment property, but if it's a dwelling, again, I don't know, so I'm not going to say one way or the other. It seems.
If I can say so, I think a more controversial issue is perhaps say the two of you, as foreigners, bought a condominium, brought the money into the country to buy that condominium. And let's say, God forbid, this never happens, both of you are killed in a car crash, and then your executors are going to sell the property, or your executors might be perhaps a child from your previous marriage, and the child says, I want to take over the property, I want title transferred into my name, but that child who's a beneficiary may not be able to do that. And I believe that's controversial. I've welcomed the views of Thai lawyers. Can the title be transferred in that situation? Because it's not the child who brought the money into the country, it's you, and unfortunately
you're a statutory heir. So as a result, you cannot own the land again. You can't own the property, so you have to sell it.
So that's one, because it's been, you have to do the succession proceeding in Thailand.
Yeah.
When you complete it, and then they will have time limit, about approximately 1 year
One
for
year,
the property and the land, and then you have to sell it. However, if you have the reason enough, you can also send a letter to explanation to the land department that you have the reason why cannot sell the property yet. However, you intend to sell it.
All right, basically that deals with the time.
Yeah.
But the principle then is that the child who wants to take over the property cannot do so. Is that correct?
No, not unless they qualify under Section 19. They'd have to come and they'd have to qualify as a right of ownership.
So to my mind, that right of foreigners to be able to buy condominiums actually is only a personal right during your lifetime, and it doesn't apply to your beneficiaries.
Yeah.
Your beneficiaries can't take advantage of that right.
I guess the only way is that you have to sell the property, the executor sells the property and the proceeds.
So your beneficiary gets the cash.
Yeah.
Yes.
Really, the property also, you have to refer on the juristic officer. If they are still have the cap, for the foreigner can be hold on that unit, because they have the limit.
Let's assume that they're within the 49% cap.
Yeah.
I'm assuming that.
Yeah.
But the issue is, as often happens,
Yeah.
children would like to take over their parents' property. So the issue is, can they do that?
I mean,
They have to set up a company.
we've got a case in point for a Belgian gentleman down in Chonburi, and his son has actually decided to relocate here for that very purpose, because he's taking over an 11 million villa. So he's specifically asked his company to move over here and is coming over to Bangkok in order to inherit his father's estate, because he will then qualify. But again, it's only a superficies right that he's taking over, because he can't own the land.
On that basis, if you're married and you've got this property, which I can't have any ownership of whatsoever because of the mortgage, and my wife passes away, that means would that be left to her family, because I don't have a right to?
Well, it depends on what she's put in her will, but if
so the will can direct.
Oh yeah, the will. She can direct that the property is left to you, or 50% is left to you, or however she wants to do it. The problem is have you got 100% security? The answer is no, because if you change the will and you don't know about it, then that's your problem. And that's where a lot of people don't register their wills. If they do, and it becomes public knowledge. But
so will become public knowledge.
If you register it, you can then go and see it. Beneficiaries can go and see it.
Oh wow.
Yes, sir.
I just want to clarify one more time. So my kids actually live outside, are not a Thai, and
they live in America and one in Australia.
Yeah.
And I own a condo.
Yeah.
So when I die and it's in the will that they inherit those, they cannot, I cannot transfer.
They cannot, they become what we call statutory heirs. So in other words, under law, they do actually have a right over the property, but they don't have a right of ownership in the same way that you do. So the government will give them a period of 1 year to actually either sell the property or come over and qualify as an owner and live in it. You know, and that means that they have to become, you know, one of the qualifications that they come here and work under a work permit.
Perhaps as it's perhaps we can formally close the meeting. And if Gav is available to stay, he may be able to have some private words with you afterwards. But can I formally close the meeting? I think it's been an intriguing and most interesting meeting. And I think, as in all things, if you're making a will in a foreign country, if you're a foreigner in Thailand, or you're, as a foreigner, you want to buy property in Thailand, the most important thing is get good advice. Don't rely on what people tell you over a bar stool. Go and get professional advice. Get a proper will drafted. Then you're not stuck with the intestacy rules in Thailand. And if you're wanting to buy a house or a condominium, whether you have to bring the money in or not bring the money in, get professional advice, and that's the most important thing. Can I ask for a nice warm round of applause for Gav? That remains at the back of the room.
Right, time for a drink, Stephen. Thank you for being moderator. Thank you very much. Yes. Cheers. Yeah, cheers. Thank you. Sorry, thank you. Yes, sure. Essentially, you need to be living and working. You can apply yes, I think the important thing that's what I house registration proves that you own property. Yes, that qualifies.